Magandang buhay, beautiful people! My name is Laynesa, and I'll be discussing the cost of contracts from Article 1G50 to 1G55. Article 1350. In onerous contracts, the cost is understood to be, for each contracting party, the prestation or promise of a thing or service by the other. In remuneratory ones, the service or benefit which is remunerated, and in contracts of pure beneficence, the mere liberality of the benefactor. First of all, what is a cause? Cause is the essential or more proximate purpose or reason which the contracting parties have in view at the time of entering into a contract. So, sa madaling salita, cause is the reason why we assume the obligation that explains and justify the contract. So now, let's distinguish the cause from the object. In a bilateral or reciprocal contract like purchase and sale, the cause for one is the subject matter or object for the other, and vice versa. Hence, the distinction is only a matter of viewpoint. So let's have an example for us to understand. Sheila sells a watch to Buboy for 2,000 pesos. So, as far as Sheila is concerned, the subject matter or the object is the watch and the cost is the price. And as regards to Buboy, the subject matter is the price and the cost is the watch. So, in a school of thought, however, these distinctions, the cost for Sheila is the delivery of the price, and for Buboy, the delivery of the watch. But to both Sheila and Buboy, the subject matter of the transaction is the watch. So now, let's move on from the past. Now, let's move on from the classification of contracts according to cost. So, first is onerous contracts. One, the cost of which for each contracting party is the prestation or promise of a thing or service by the other. So, in onerous contracts, they are reciprocally obligated to each other. So, yung cost or consideration in onerous contract is the prestation or a promise of a thing or service by the other. So, kaya tayo pumapasok sa contract kasi may promise yung other party sa atin. That's why we considered it to enter into a contract. So, the best example for onerous contract is the contract of sale. The next one is remuneratory or remunerative contract. One, the cost of which is the service or benefit which is remunerated. So, if the contract is in remuneratory, the cost of contract is the service or the benefit which is remunerated. It is to reward the service that has been previously rendered. So last is the gratuitous contract. One, the cost of which is the mere liberality of the benefactor or giver. So if the contract is a pure beneficence, the mere liberality of the benefactor. So it is voluntary or bukal sa loob natin. Like, the best example is the donations. Article 1351. The particular motives of the parties in entering into a contract are different from the cause thereof. Motive is the purely personal or private reason which a party has in entering into a contract. It is different from the cause of contract. The cause of contract is different from the motive because cause of contract is the objective and juridical reason for the establishment of a contract and is always the same, while motive is the psychological or personal purpose of a party in getting the object and differs with each person. Each party may have his own personal reasons or motive in entering into a contract. Motive or even with illegal motives does not affect the validity of the contract. So now let's have an example. V buys a knife worth of 2,000 pesos to JK to kill Ayu. So the cost of contract to V is the knife and the money for JK. So the transaction here is valid, or the cost, but the motive is illegal because the motive of B is to kill Ayu. However, the motive does not affect the validity of their contract. Cost distinguished from motive. As contradistinguished from consideration or cost, motive has been defined as the condition of mind which incites to action, but includes also the inference as to the existence of such condition from an external fact of a nature to produce such a condition. Let's now have the differences between the cause and motive. Cause is the immediate or direct reason, while motive is the remote or indirect reason. Next is cause is always known to the other contracting party, while motive may be unknown. Motive may vary while cause is always the same. And next, cause is an essential element of a contract while motive is not. And the last, the illegality of the cause affects the validity of a contract, while the illegality of one's motive does not render the contract void. So, as a general principle, the motive or particular purpose of a party in entering into a contract does not affect the validity nor existence of the contract. The motive may be considered the cause in a contract when such motive predetermines the cause of the contract. So now let's go to Article 1352. Contracts without cause or with unlawful cause produce no effect whatever. The cause is unlawful if it's contrary to law, morals, good custom, public order, or public policy. So according to Article 1352, without a cause, the contract is void, so it would produce no effect. And also if the cause is illegal, your contract is also void. So now let's proceed to the requisites of cause. First, it must exist at the time the contract is entered into. So the cause must be present, kasi if not, then magiging kulang ang essential requisites of the contract, which is consent, object, and cause. So, the cause must be present. So, next requisites is the cause must be true or real. And the last one is it must be lawful. Lawful means it is not contrary to law, morals, custom, public order, or public policy. Effect of absence of cause. Absence or want of cause means that there is total lack of valid consideration for contract. Effect of illegality of cause. Illegality of cause implies that there is a cause but the same is unlawful or illegal. So if the contracts with unlawful cause are void and null. For example, a promise of marriage based upon carnal connection. Let's now go to Article 1353. The statement of a false cause in contracts shall render them void, if it should not be proved that they were founded upon another cause which is true and lawful. So Article 1353 simply talks about the effect of a false cause. So what is the effect of falsity of cause? By falsity of cause is meant that the contract states a valid consideration, but such statement is not true. A false cause may be erroneous or simulated. So, pag sinabing erroneous, it is not correct, not accurate, not valid, or it is false. Pag sinabi namang simulated, it is something that is made to look real or genuine but it is actually fake. So dito sa effect of falsity of cause, if the cause is false or absolutely simulated, the contract is void. But if it is proven that the parties have intended another contract which is the true cause, then the parties are bound by their true agreement. So for example, the real transaction is sale, pero para makaiwas sila ng tax liabilities, pinalitan nila ng donation. So according to law, the contract is not void. Pero kailangan nilang ma-prove na yung other cause is true and lawful, and the parties should comply their true intentions or agreement. Now let's move on to Article 1354. Although the cause is not stated in the contract, it is presumed that it exists and is lawful unless the debtor proves the contrary. Question: is it necessary for the cause expressly stated? The answer is no. It is necessary that the cause must exist, but it is not necessary to state the cause in a contract. That's according to Article 1354. For example, Danny issued in favor of Chris a promissory note which recites, 30 days after date, I promise to pay Chris or order the amount of 1,000 pesos. Signed, Danny. Although the promissory note does not mention the consideration, the law presumes that Danny must have received a consideration for the debt and that the same is lawful, and furthermore, that it is sufficient and adequate. Let's now go to the last article, Article 1355. Except in cases specified by law, lesion or inadequacy of cause shall not invalidate a contract unless there has been fraud, mistake, or undue influence. So what is lesion? Lesion is any damage caused by the fact that the price is unjust or inadequate. It is the injury suffered in consequence of inequality of situation by one party who does not receive the full equivalent for what he gives in commutative contract like sale. So, for example, you have a car na ang real value is 500,000 pesos and binenta mo lang siya for the price of 250,000 pesos, half ng real value ng car mo. So, there's a lesion there kasi yung price is inadequate or kulang. So, what would be the effect of that to our contract? So, as a general rule, lesion or inadequacy of cause does not invalidate a contract. So, sabi nga ng law, you have the freedom to make your own stipulation. Baka gusto mo lang talaga ng mas mababang price para mas mabilis mabenta yung car mo, kaya binabaan mo yung presyo. So, there are two exceptions of lesion will invalidate a contract when there has been fraud, mistake, or undue influence, and in cases specified by law. That's all, guys. I hope you learned something about my report. God bless.